Good evening, everyone, and thanks for coming. I think the topic of today, we want to understand intellectual property, especially insofar as research is concerned. Yeah, I'll try to align my topic insofar as research, but also trying to understand the broader concept of intellectual property, because it's also applicable in our research aspect which we are doing. So I'll give some few examples there and there. Let's look at how intellectual property comes into research. And I think it's something which we need to make sure that we take care of, all right? There are few outcomes. The first one, I want us to understand what is intellectual property in general, all right? And also understand the different types of intellectual property, and also specifically to research. I want us to understand what is an open access publication or publishing, if I can put it that way, okay? And also understand what is Creative Commons. You see, when we look at what is happening in the previous years and what is happening now with our publication, there's something which they call it Creative Commons. I'll try to explain, not in detail, but some of you, as you are going through some of the articles, some of the things you'll see in those articles, okay? So that you understand their meaning. And also understand the licenses condition under the Creative Commons, okay? It's a license. When you publish, the publisher, or the platform through which you publish with, they have what you call a license, okay? I can give an example in my case. There are other publications which I've made, and I've made them through maybe a book chapter and so on in a certain publication, okay? Before I can take the content, all right, and put it as available, especially in the platform which I normally use, which you call the ResearchGate, all right? The ResearchGate. Before I can put that in the whole article under ResearchGate, that will appear under my name, so that whoever wants to read that, they will be able to read it. I need to look at the license, okay? Some of them, I can't put them to be accessible to everyone. There are conditions, especially if the publication is not an open publication for access purposes, okay? Some of them may find that you have published, but for other people to be able to view your publication, they need to buy that document. So that's why I can't just download the whole publication, all right, under that platform, because I could be contradicting the license and the condition which have been afforded for. And others are open, definitely. We also have open access, where even the document or the article, it's available to everyone. You can even download and do all those things. But what I've seen with the publishers now, or the publishing houses now, what they do, if it's not an open access platform, they show you a synopsis of the publication. It could be a general publication or maybe a book chapter publication. We are not able to read everything. The other content is being reserved, because remember that you need to buy that document, so they cannot show you everything. So all those things that are there for us as students to have a clue about them, so that we don't get ourselves into trouble. Okay, few terminologies. I think all of us colleagues, we know that there was something which was happening, I think this week, if I'm not mistaken. Yeah, there are other organizations, there are cases in regards to the issue of intellectual property and copyrights. They're still going in court and all of those things. So what I want us to understand is that if you have an idea, all right, whether it could be a research idea, and you share it and you don't protect it, then it doesn't belong to you. I think I've done many of the examples during my presentations to say maybe this is an area where you can tap in going forward with your research. Because I didn't protect anything. Anyone can take that. And if, for example, I suggest that you can do research about this aspect and you take it forward, I cannot come out next time if I see you have published that idea. No, because I didn't protect it. But if I've protected it, definitely I can take you into task. Okay, so in other words, we always encourage our students. If you have an idea or something to research about, don't share it loudly in any platform. Well, it could be social media, could be maybe with friends and so on. Don't share because other people, they can take your idea and you cannot claim it to be yours. Okay? The only time you can share if you have started to work on the content, for example, in your case, if it's a research project, you have been given ethical clearance around it, that's yours, definitely, because you have worked with the supervisor and all of those things. But if that process have not unfolded, you cannot claim and say that's your idea. Okay? But let's look at few. There are a lot of concepts we'll be looking at or terminology. The first one, let's look at what copyright is. They say it's a form of legal protection given to the creator or creators of original work or authorship. The copyright infringement, what does it mean? It's a violation of the exclusive rights of a copyright holder. I've just given you an example now to say if, for example, the condition or the license which I was given in regarding to a certain publication of my book chapter or my journal article by a certain publisher. If it says I'm not supposed to share the content with anyone, it's not an open resource, then I decide to go to ResearchGate and try to upload the whole document. I can be in trouble. I can be found to have infringed the copyright because I'm doing something which has not been allowed. Okay? And those are some of the examples there of said, such as copying, distributing, or performing the copyright owner's work without permission. Always, let's get permission. The same thing, colleagues. You are doing research currently. Whatever you do, like I always say to you guys, whatever you do, liaise with your supervisor so that you're not in trouble. Okay? And you'll see when we talk about publications in one of the sessions to say, I can't, as a student, you cannot just after you completed your dissertation or maybe your thesis, then you go and publish on your own. You cannot do that. There are conditions which the institutions have put in place. And I know the common one which has been put in place by most of the institutions is that the first publication which you publish under your research outcome, all right, you have to publish it with your supervisor. I can't just go and publish alone as a student. The supervisor needs also to be part of that. That's why most of the time the core publisher of that content is going to be you as a student, then the supervisor will be the second core publisher also. Okay, but after that, most of the institutions, they will tell you that after that, you can publish on your own. You don't need to include the supervisor. Sometimes you find that in your master's dissertation, you have 3 publications. Maybe the first one you include the supervisor, then the other 2 can publish them on your own, or you can publish still with your supervisor. Okay, so those are some of the conditions we need to be aware of. Then I'll explore also this term of intellectual property. Basically, is a creation of the mind, but I'll explore it, I think, in the next slides. What is intellectual property in detail? Okay. Then spoken about the license. It's a permission to use a creative work. That's a license. Okay. So we need also to understand all those licenses which are given, especially in regards to publication. Okay. For example, I just want to go quickly to this one. If I do any work, right? And I do any work under the institution like UNISA, all that material belongs to UNISA. Whether I'm the one who went out and researched and all of this, but it belongs to UNISA, not to me. Okay? The same thing, like you as a student. Whatever you do and the supervisor is there, it means all that content or that work or that creative work which you bring in, it belongs to the institution because the supervisor works for the institution. I always have a problem with colleagues sometimes when they develop PowerPoint and all of those things, and we say they are creative. We are not creative. That's why we encourage our students to say whatever content which you have taken somewhere, make sure that you provide correct reference for that, right? As much as possible, okay? Because it's not your idea, honestly. But we are not saying that, for example, in my PowerPoint, for everything I'll provide a reference. Sometimes others will say, no, if you have done in-text citation of the content is enough. Others will say, if you have done only references, it's enough. But at least you know that you went and researched about this aspect, and they belong to other people and so on. So you acknowledge. I think we've spoken about that one in one of the presentation. Okay. Maybe let's quickly look at what is intellectual property briefly. I think I've visited this source. It stands for Open Learning Group. In one of their study material, they describe intellectual property, and they say it refers to any information that a business will want to hold confidential. Okay, that's intellectual property. In other words, it belongs to them. If I disclose the content of that, I need also to acknowledge them because it's not mine. Okay, or maybe sometimes I also need to get permission. I was thinking about intellectual property in a different way today. For example, all of us, we have our grade 12s. No one does not have a grade 12 now, is it? All of us. But if you look at your certificate for grade 12, and you look at that certificate, most of the time, you'll find that the basic education logo, maybe it's there. I'm hoping it's there. Okay. Then from there, they include your details. Could be maybe your student number, or maybe your ID. In your case, it was our ID numbers in our case, and also your name. So what does it mean? It means even though this certificate belongs to you, the people who have ownership over this certificate is still the basic Department of Education. If let's say there's someone who wants to get your details, okay? You want to work somewhere, let's say in another country, for argument's sake, and they want to find out if you as a person whose name or details appear in the certificate, they want to check if you've acquired the qualification. They are not going to contact you, okay? They are not going to contact your school. They are going to contact what you call South African Qualification Authority, which also works with the Department of Education to check that your qualification is being registered with them. In other words, they become the custodian, right? That's why we say some of the content are more confidential, and sometimes as when you want to share them, you need sometimes to get a little bit of permission around that. But look at what intellectual property indicates there. It says intellectual property, which usually originates from an intellectual exercise, will include some of this. Copyright is one of them. In our case, I think in education, especially in research, we are more on the copyright, is it? We are not on the patents most of them. Yes, those who are in other disciplines, for example, science, they'll talk about patents and all of this, is it? Because sometimes they create some processes there and there, okay? Then you have trademarks, then trade secrets, okay? And I think most of the time, those who are in business, they have what you call trade secrets, okay? For example, if you can look at some of the um, some of the retailers, for example, and some of the food outlets. If you look at maybe different, let's take one. Let's say, for example, KFC. They don't share their secret recipe, is it? Because it's theirs and they've registered it. You can't use it. Okay. If you find, for example, they share it with another or institution or organization, you must know that there was an agreement around it. Okay. But most of the time, they are the owner of that recipe. Okay. And they've registered it. While it also refers to creation of the mind, such as invention, literary, sorry, I always struggle with this word, and artistic work, designs and symbols, names and images, which are normally sometimes used in commerce. That's according to the World Intellectual Property Organization. I think further we need to understand intellectual property as a pro-competitive legal mechanism. It's more legal, okay? It also covers aspects such as novelty, uh, inventiveness, creativity, and also what you call originality, okay? There must be something which is original there and also be distinctive. In other words, there should be something which is not the same with others, okay? Look at the concept originality there. The case I was just referring to, which I can't even, I think most of us, we have seen it, we know about it. There's a bit of being original there, okay? But what I don't know, the claim is that when this person come with this, yes, he was working for the organization. I can't mention it now so that I don't want to be in trouble. But the creation of that concept, the argument is that it belongs to them, to the author, okay, or to the person who was working in that organization. So another aspect is that when this creation of this concept was done, was the person was using whether the organization resources or not. I'm not sure about that, but at the end of the day, it's clear. It's clear. That's why the case is dragging a little bit long. I don't know how long they're going to finalize that case. Another thing about intellectual property is that it protects society against free riding across these forms. Counterfeit, okay? Counterfeit is one of them. We have seen that in clothing, is it? Because sometimes people, they'll come with clothes which are not original clothes, and they sell it at the highest price. We've seen it mostly in unfair competition, okay? And also we're seeing it in parastic, okay? And now I want to talk about the unfair competition. We know what happens, especially during 2010, if you were able to follow some of those things. I think before 2010, there were a lot of bridges which were built, let alone the e-tolls and also the stadiums. And if you can follow the argument there, some of the organization or companies which are in construction, they were accused of price colluding and they were fined. Okay. In other words, the prices were so high and it cost the government a lot of money. So it was more of unfair competition because others were not able to make some sales because there was this colluding among some of the big construction companies. But I think that these 2 points are very important. It is more about the respect and honesty. We need to be honest, okay? And that's why we try by all means to ask our students to ensure that if something is not coming from you, it's not your content, you took it from someone else's work, you need to acknowledge. Okay, we need to acknowledge as much as possible, okay, to safeguard ourselves. I'm not going to spend a lot on this, but a little bit. I don't know, colleagues. I've looked at the history of the intellectual property, and I've visited some of the sources there. Okay, but what I've picked up is that it's not a new concept. Okay, it's something which has been happening. It's been happening even by the year 600. That's before the Christian era. There was still intellectual property. If you can look there, there was a person by the name of Jacob who argues that the first item to have an IP, whereby something which it has an intellectual property. It was a culinary invention, all right? And it also had a little bit of intellectual property, because they wanted to protect it. But if you go further, also in the year 1400, also there, okay, they say the world's first modern patent was awarded to an Italian inventor, okay, and went further on the 1600s. The statute of monopolies appointed individuals to control this industry. And I want us to focus from here most of the time to say now it's a big industry now, right? And if you look where it started and you look where we are now, we have what you call the World Intellectual Property Organization, which was more started to operate in 1970. Okay, so I think this formalization starting from here, it leads to this World Intellectual Property Organization. Okay, so but it went further to say on the 1700s, right? A statute of Ain, which was awarded authors a 14-year protection on their work. In other words, authors now on the 1700s, they said, whatever creation you have, we award you to protect it for almost 14 years, right? Then it belongs to you for only 14 years, okay? But if you look where we are now, especially under the World Intellectual Property Organization, your idea, your creation is being protected forever. No one can take that idea. It's yours, okay? Think about you as a student. The dissertation you are going to put as an output, your thesis, the manuscripts or articles you are going to publish, they are going to be yours forever. That's why you are going to be cited not only after you publish your first article. Whoever is going to look at your work, even after 60 years or 100 years, they're going to cite you, colleagues. They are going to cite you, okay? Well, there could be maybe the citation, it can come to say maybe in your work as maybe supported by this author, but your name is going to be there because you are the original creator. Then you can also go through the rest. But when you look at the World Intellectual Property Organization where we are, it says it was established through a convention that was signed at Stockholm in 1967, okay, and came into operation in 1970 under the auspices of the United Nations, okay? I think most of the things they come into operation under the UN most of the time, okay? And also through it, though it could be traces from 1800 within the 14 member countries who signed the Paris Convention, okay? I think you can look at here, 1883, there was what you call the Paris Convention in regards to the IP, which was signed by a few members. I think there were 14 by then. But now, if you can look at the members who are falling under this organization, the World Intellectual Property Organization. We are sitting at almost 193 member states. I think South Africa is part of that. So it's a lot. It's almost everyone follow this organization, and they register whatever creation in the form of IP with this organization, so that no one can use your idea. That organization becomes a watchdog. So no, there is a creation about this and that and that. So you cannot come and claim to be yours. Okay. I think most of us, we know about these types of intellectual properties. Maybe we have studied about them in different maybe modules or subjects and so on. A patent, basically, it's a government grant giving the inventor of a product or process the inclusive right to manufacture, right, exploit or use and sell that invention or process. Those who are in other disciplines like sciences, they can also come with a sort of an invention, and they can patent that invention in their studies and so on, okay? A trademark and trade names are designs and names often officially registered by which merchants or manufacturers designate and differentiate their products, okay? We know about the trademarks and the trade names. That's why the trade names normally, sometimes others, they use a symbol, okay, for the trade name. Then we know if this symbol comes, if, for example, the University of South Africa, they have their own symbol. If it comes, we know that it belongs to UNISA, okay? Copyrights are exclusive legal rights of authors, composers, creators of software, the playwrights also, and also artists and publishers to publish and dispose of their work. I think we fall more on the copyright in this discipline of education and so on. Then we have the trade secrets. We've spoken about the trade secret, any information that the business wishes to hold confidential, right? Let's look on how to protect the organization's IP, okay? And also how do you make sure that you can protect your own, okay, idea. In some instances, definite organization may include these terms on employees' contract so as to protect their IP, especially if you are employed. This and some of these things, colleagues, some of these aspects, they are not explicit. Okay, they are not explicit. Think about, if I can just give an example. Remember that when this process of using TikTok came, you find that most people in their employment places, they'll make sure that they have those TikTok things and so on. And some of them, you find them wearing their organization's clothes, and also maybe within the organization premises. And it became clear that that's not allowed. I can't develop a content and still in that organization without the permission. So I need to get the permission. Okay, so what I'm trying to say, colleagues, especially those who are working, we need to be careful about some of these things. Otherwise, you'll be found wanting. So yeah, we always like to say things, isn't it? But sometimes we need to be careful about what we normally share. Ownership of IP. What does it mean? Start stating that any creation by the employee during the course of employment belongs to the organization. I think I've mentioned that one. That's ownership of intellectual property. If I do something and I'm employed by this organization, it belongs to this organization. That's why other organizations, when you leave them, okay, let's say you get a position somewhere or a work somewhere, you are leaving this organization, they may come to you and say, you can sign a clause to say you are not going to share any of these contacts. We've seen it most of the time, especially those who are in sales. Let's say, for example, in sales, as a sales manager, definitely you have people whom you have been selling product to and so on to those clients. They may ask you to sign an agreement to say you are not going to try to get any of those clients which you manage to source when you're still working for them. So those are some of the conditions, colleagues. Okay. Then we have also another one which is called the confidential information. Any information that pertains to the organization will be kept confidential. And I think sometimes we as human beings, we don't understand the issue of confusion to be confidential. By confidential, it means you are not supposed to share anything about the employer, as long as you're employed in that organization. Anything. Okay, so we need to try and always to, like I was saying, not to share a lot. Let's keep some of the things to the organization. They belong to the organization, by the way. For example, I'll make an example about salaries. Okay, I'm not supposed to go and disclose to say, okay, in our organization, our salaries are like this and that and that. We know people they know about some of those things, but in the legal term, we are not supposed to disclose some of those things. They are very confidential, colleagues. Any information that pertains to the organization will be kept confidential. I think I mentioned that one. Not disclosed to another person, nor used outside the course of employment by the employer. In other words, what they mean, whatever belongs to organization A, it must stay with organization A, even though you have moved to organization B. Everything must stay with the original organization. We are not supposed to share some of those things. There is also what you call, when they want to protect the IP of the organization, the organization can have something which you call restraint on competition. I think I've mentioned that one. Okay. To say, I was listening to something today, and it's so strange. Some of these things, when you share with our students, they are there in real life. I was listening to another radio station, right? Just today when I was coming back from the other employment, or my employment, the full-time one. So I was listening to this radio station, Ukozi. Okay, well, I listen to it most of the time. So what they're talking about, I think they have employed a new program manager. Okay, so the presenter was interviewing the new appointed project manager, together with the head of the radio station itself. There were two there. So one thing which the project manager wanted to find out, because the presenter was asking something which could put the whole organization into disrepute. They were asking him to say, you can share maybe the previous employers you have worked with. Before even this project manager could mention the names of those previous employers, he asked first with the head of Ukozi, or the head of the station, is it proper for me to mention those organizations on air? And I found it so strange, and I found it to be the best way to do that. Because if he started just to share the previous employers on air without the permission of the station manager who was there in that process of the interview, he could be found wanting. And also maybe even those previous employers, they can even sue the current employer which is ukhosi, to say you have mentioned our name on air without our permission. So now, in order to avoid some of those things, you have to find them. You have to get the go ahead. So that's how we sometimes they want to restrain on competition, because remember this, all these people that are in competition. Okay. And the same thing with us. Sometimes when you move to another employment, they may have that aspect to protect the IP, where they include an aspect of restraining insofar as competition. In other words, you could not cover aspects such as customers cannot even go and talk with your previous customers when you were in that organization and you're moving to a new one. The suppliers also cannot, you're not supposed to contact those suppliers or try to recruit those suppliers in your new employment. So those are the things, colleagues, we need to be familiar about insofar as the issue of the IP is concerned. Okay? The same thing in research. There are things, colleagues, which are more confidential. Okay? If, let's say, I want to give a simple example. If, let's say, they appoint me and say, welcome, we appoint you to be an external examiner of this student, right? Let's say I'm appointed by institution A, okay? Then from there, I need to sign for the clause of confidentiality. In other words, that to say I'm not going to disclose any information here. Then I put my signature there. Then I decide as welcome, because I'm so excited, then I share it with someone else. Okay? Maybe I share it in a public space. And when I share it in the public space, I don't know who's listening to me now. Then I say, okay, you know what? I've been appointed to be external examiner of such and such a student from this institution. Not knowing that within that space, there is someone who knows the person you mentioned. And sometimes maybe I even disclose more confidential content to say, no, I don't think the student will make it, and this and this and this. What will happen if that information leaks and I've signed for the confidential clause? Then I'm in trouble. Can you see now? That's why I'm trying to say, colleagues, we need also to try to ensure that what is confidential, we keep it to be confidential as much as possible. But who owns the intellectual property? Interesting. Okay? The employer owns the IP. Okay? In other words, whatever you have created when you are under that employment by that organization, they own the intellectual property. In other words, we don't even have to worry about ourselves to say you went so much, you went to the library, you got information, you went to Google Scholar, you did this. But when you're working on that creation, right, you were employed by this organization A. So they own everything, as long as you are still employed with them. The only time they don't own any creation, okay, it's if you create something outside their employment. If you have moved now to employer B and you create something there, then it doesn't belong to employer A. In case whereby an employee moves out of the current employment, whatever that's new creation, he or she developed is owned by that individual, not the ex-employer. I think I've just mentioned that one. So we need to be careful about some of these things, okay? Other people will say, okay, but when I created this content, I was creating it during my spare time. Remember, as a permanent employee of an organization, you are employed for 7 days per week. you don't work on a Sunday, whether you don't work on a Saturday, but you're employed for 7 days a week. Why I'm saying this, think about the salary when you get it. Okay? They don't say, okay, because you don't work on a Saturday and Sunday, then they give you a salary for only 20 days. They give a salary for a month. In other words, the Saturdays and Sundays are counted. So that's why the creation, whatever content you make or you create outside the working hours, is still being owned by the organization. Okay, let's quickly look at the types of material that copyright protects. They protect what you call literary works, all right? I think it's more about articles, books, and lyrics, and so on. And also dramatic works. That is works that is intended to be performed or presented, okay? You can also have a copyright, like your stage plays, choreography, shows, and so on. The musical works also have been covered by copyright, okay? And also the artistic works, they are also covered by the copyright. Aspect like your paintings, you can have a copyright. The sculptures, drawings, maps, photographs, engravings, models of building also, they have a copyright. How many of us, colleagues, I want to talk about this just in general. When we build new houses, what do you normally do? You go, let's say you extend or you do whatever. As you are going around, maybe traveling, maybe in other provinces, or maybe around your area within the same vicinity where you stay, you look at the nice houses, isn't it? Just look at them. So what you normally do, you just approach the person who's going to make a plans for you, the drawing plans, and say, I want my house to be like this and that and that. Already you've copied someone's drawing or someone's house, right? And you use it as your own. Why are you not found wanting in that regard? Because that house which you have copied and you have looked at it as you are traveling, and it fascinated you to say, I want also my house to look like this and that. Then you copy that house plan or the outlook and so on. You are not going to be found wanting because the originally owner of that house didn't have what you call a copyright to protect that drawing. Okay? But if the owner had a copyright and registered that drawing, definitely you could be in trouble. Because now we are stealing someone's creation. But because normally we don't put copyrights around our drawing plans most of the time. That's why we're able to copy other people's ideas. Okay, but there are other buildings, definitely. There are copyrights for those buildings. Once you start to have, think about the shopping malls. If you look at them, they're not the same, is it? Why? Because each one of them, they have their own plans. And those plans, those drawing plans, they've been registered and they have a copyright. Once you can start and look at the mall and you copy that mall and you go and develop a mall somewhere based on that mall, then you'll be in trouble. That's why we need also to look at the aspect of art, you know, to always put copyright around those aspects. What can be patent? Okay, there are a few things. This aspect can be patent. In other words, can put a patent around them. Chemical substances. If you look at the pills which we get, they are not the same, is it? Okay. Some of them definitely there'll be the name of the a pharmacy, but when you look the way they patent them, then they can't be the same. In our case, especially those who are in science, okay, they can also have a patent in regards to the process or methods. Then you also have the product. In others, you can make patents for the products, devices also. Okay, all the companies definitely they have a patent around their devices, their laptops, the system, and so on. But for any product to be patented, it must adhere to some of this. They must be new to the world, right? It could, in other words, it should not be found anywhere. It must be new. In other words, it's a creation now. Okay, that thing must be new. Okay, inventive also, and also useful. You can't put a patent on something which is not useful. If you talk about the process, it must be a useful process. Then you can put a patent around that process. Okay. So I just wanted to share some of those briefly. But what are the steps needs to be followed in obtaining a patent? These are few steps. Okay. One, identification of the invention or ownership. The next step, eligibility of the invention for the patent protection. Step 3 is where you start to apply. And talk about application preparation, right? Which you can do it with the patent office or officials. In our case, most of the time in South Africa, in order to register a patent, you need to register it with the companies and Intellectual Property Commission, all right, the CIPC. Or alternatively, you can register the patent of the product with the law firm. You can also use their law firm. Okay? But for you to complete the application will ask you to provide the following information. It will ask you to indicate the invention title. Also, you need to provide the related application of the product you are putting a patent around it, okay? And also the background to the invention. Think about all of these things, colleagues, especially if you look at the related application. That's why always in regards to medicine, for argument's sake, they will tell you that this medicine must be taken in this way and in this way, and how many times. Where does it come from? It doesn't come from the hospital pharmacy. Basically, the product itself, it has been patented in that way. To say, for example, if it's a sort of a pill and it has been patented, definitely there's no way if that pill, when they include the application, they said you must take it in the evening or after meal in the evening. Then from there, when you go to the hospital pharmacy, they say you must take it in the morning before the meal. They must follow that application. That's what they normally do. Okay, and also what's needed to be completed also in that process is the background to the invention, what informed this invention, and also the brief summary, and also the description of the, if it's a drawing, you also need to put the description of the drawing, okay? And also the last one, I think we need also to provide the claim and the abstract. And if you look at the brief description of the drawing, if you go and, for example, and I think that's what is normally happening now. It's a requirement. If it's a DIY product and I need to assemble it in my household, and I go and buy it in a certain, maybe in a certain warehouse, or maybe in a certain shop, or maybe in a, if I get that, let's say, for example, maybe it's a bed, then I need to assemble it as a DIY, they also supply you with all those things in regards to the description of the drawing, to say when you assemble it, you must follow this step and that step and that step. So all those things, colleagues, they have to do with an aspect of when you register a patent. They may ask you, okay, if it's a product which is supposed to be assembled. When you register it with CIPC, you also need to submit to supply to include in your forms the aspects which are related to the description on how this product is going to be assembled. It's a requirement, okay? And the first step, definitely, after you have completed the form here in step 3, then from there, you file for the application. Then after that, if there's an issue, they address an issue. If they want to get more information from you, or if you want to appeal the patent, if you feel that maybe you were supposed to get this patent as you wanted to register it, and they say, for example, CIPC decline, then you can appeal and so on. Or maybe decide, oh, let me just abandon this resolution of this product in the form for its patent and so on. So you have to make some of those decisions. Copyright. Okay. Like I was saying, some of the things I'll be sharing, especially from now, you'll see that when we are reading some of the material, could be books, could be articles, and so on, you'll see some of these things coming up, okay? But the copyright, there's what you call the Copyright Act of 1978, all right, which stipulates that when you create your own work, that can be seen or heard in the form of a book, paintings, or music, copyright is automatically secured. So in other words, you don't need to go and register for a copyright. It's automatically, unlike the patent, okay? The patent, you need to register for it. Okay? Therefore, no registration or any other formality is required, except in the case of if it's about cinematograph films, okay? Then you have to register that copyright with CIPC. In our case, our articles, our books, we don't need to register for copyright. Automatically, it's granted. Okay? So that's why most of the time, when you look at our books, you find that they have this symbol, which stands for copyright. In other words, this content belongs to this person, okay? In this instance, you can create your own copyright by putting the word copyright or copyright reserved. In other words, you don't need to go to any institution. And remember that when you register a patent, there's money involved, by the way. It's not free, is it? Okay. So now in a copyright, you do it on your own, definitely you are not going to spend any amount of money. You can put a copyright around all your publications. If, let's say, for example, I'm looking here, I'm having few of my dissertation and some of my reports in front of me here. I can just go at the first page where my name appears, then I put this symbol on my own. Copyright or copyright reserved. That's it. Okay. In other words, everything belongs to me. I've just make it as an example there. Or you can also, they say you can also use the international recognized copyright symbol, followed by your name and the year, teaching the one I've just displayed now. It's just an example, colleagues. Okay? And this work remains the property of Ubega. Okay? In other words, I also put the rights there. And they may not be reproduced nor distributed in any way. So it's no one is supposed to distribute it or produce it or reproduce it. If you do that, and there's a content on the documents which have put a copyright and reserved, then you need to cite the author there. Colleagues, please. I've looked at this one, the flag of South Africa. And first, it was not developed by me, please. Don't mistake it to say I've put a copyright around it. I just put it as an example of whether it's a copyright. No one can come with a similar flag and also the colors and so on, because it's reserved for only South Africa. Okay? But who owns the copyright? Persons who creates or makes the material. In the case, the example of Opega, I own that copyright. That is the author or writers. Copyrights can be transferred to another person. Right? I think that one we'll look at it, especially when we talk about publications. Okay? But copyright confers economic rights, control of exploitation, insofar as reproduction and communication to the public. Also, when you look at the economic rights, they relate to the economic exploitation of the work and freely transferable or licensable. Okay? In other words, we try to protect other people's work, right? So that they should not exploit or benefit without acknowledging the original creator of that content. It also assists insofar as moral rights. It prevents the mutilation or false attribution. We are going to talk a little bit about the concept of attribution, especially when we are looking at some of the license. Okay? We are going to look at this concept of attribution. It also, in regard to the moral rights, it relates to the moral interest of the author, are always retained by the author. Okay? So let's quickly look at this exercise. It says TEPO is employed as a software writer by X Technologies. His employment duties are to write software programs to be used in the management of databases of inventory when equipments are transported by rail. During his spare time, Seppo spent most of his time developing new computer games using the employer's laptop and software development programs. Seppo licenses this developed computer game for a license of 20,000 and royalties of 20% of sales. Look at that and tell us if X Technologies own the computer game that Seppo has developed. Do you think that that computer game, which was developed by Seppo, is owned by X Technologies? Or whether it's X Technologies also entitled to all these monies? Remember that based on the licenses of the developed computer games by Seppo, they are going at amount of 20%, 20,000, sorry, and also a royalty of 20% of sale. Basically, I want to find out if X Technologies also is entitled to this amount of money. The first one says, SN, you're saying X will own the computer game and is entitled to all the monies. I like that one, eh? Yeah. Let's look at the others, what they're saying. Yes, I think MR, we are saying, yes, I think the organization is also entitled to the share since Seppo use their resources on the games. Also interesting, X will own the computer game. They might argue TEPO use the resources of the organization. Okay. Also interesting there. Let's look at the LT, what you are saying. The work that was created was within the scope of employment. Okay. And TEPO used the employer resources. So in this case, X technologies can claim for ownership, I think. Okay. AR, you are saying, while employed, any invention developed is owned by the employer. Okay. Yeah, we can argue it in different ways, colleagues. And thanks for your input. But if you can look at this scenario, definitely, TEPO was employed for something else by X Technologies, isn't it? He was employed to his employment duties are to write software programs to be used in the management of database of inventory when equipment are transported by rail. That's the duty and the responsibility of SEPA, according to X Technologies. But SEPA decided outside his employment roles and responsibility to go and develop computer games, and at the same time using the program of the software development program of X Technologies. And TEPCO made more money, definitely. All right. For one license, it goes up to 20,000, and also the royalties of 20% of sales. But if you look at this scenario, definitely everything. That's my argument, colleagues. Maybe people of will disagree with welcome. But I believe that everything which TEPO has done beyond his employment condition, he can't get remuneration for that. It's a fact. In fact, the company can even take him to disciplinary hearing to say, look, you have used our resources without our permission, and you have used it outside your scope of work. So TEPO can even lose more of the sales. In fact, when I look at it, if it can go to a court of law, well, as a layman, honestly, you may find that whatever licenses he has issued up to this far, the organization can claim that those license monies belongs to the organization. Well, someone can argue differently, but I know that some of you have a different point of view. But looking at this scenario, except, maybe I can just go further, except if TEPO has declared to the organization, to X Technologies, okay? Because other organizations, they always say to you, if you do job outside the scope of your employment, there's a form which you always complete. If in regards to X Technologies, they also have the same position, and TEPO has declared to say, okay, I'm also doing A, B, C, and D. Whatever money TEPO will get outside whatever those licenses and royalties, they are TEPO's money because you have declared. And remember that if some of the organizations, they say you must declare, then from there, that's the one also who needs to give you a go ahead. Doesn't mean that if you've completed that form to say beyond my work, my scope of work, I'm doing APC for this organization. It ends up there. They must give you permission also and agree. If they agree to say do it, I think should be most of the time it's in writing. They also sign the form. Then TEPO definitely would able to get more of that money. In fact, not. I think almost that all those um, that money through the licenses and royalties belongs to SEP, and he just have to work out with the SARS. Yeah. But yeah, I think those are that's my take on these things, colleagues.
Sorry. I was going to say that you can declare the outside interest, but even if you declare the outside interest, generally when you take you sign your agreements with your employments, the utilization of like company assets are only meant to be for um, companies time and resourcing and working on those activities. So, yes, you could declare outside interest by saying you possibly employed for another company or you're doing outside work. But generally, under those circumstances, you should not be using your employer's assets to conduct any sort of business or activities around that, though.
Yes, I agree with you. I do agree with you. But what I've noted, especially in some institutions, uh, still I can do an outside task beyond my employment task, and I can declare that. And normally, when you complete the form itself, it depends on the employer. But some of the employers, when you complete the form, they also ask you, are you going to use the organization's resources? So you have to be upfront. If you are going to use if you say yes, I'm going to use the employer's resources, definitely. Most of the time they agree about that, but others they say no, they don't have that option. They'll in their form they'll tell you that whatever outside task you do, you are not supposed to use any of our resources. But indirectly, you are using the organization resources. Maybe sometimes the most tangible ones, like for example, the laptops are more tangible. But indirect, the time, if you look at the time, it's within the organization space, because let's say I'm doing these things over the weekends and I'm employed definitely for Monday up to Sunday, even though in a true sense sometimes you don't work on Saturday and Sunday, but it's still within the employer's time zone. That's why what's important is that organization, they've put those things into place, okay, to say you must tell us, okay, so that you don't be found to want. And other people, they think that, if I can make an example, nowadays there are many workers or people who are having more than one task, okay, and some of them is online, and people, they feel that because I'm doing something online, I don't need to inform my employer. You have to inform your employer, even though it's something online, or maybe with an international company and so on. You need to declare, so that if anything happens, they discover, you know that you're on the safe side. That's what we were trying to share with you guys, especially those who are already on the employment. Others, some of you maybe are not all on the employment. But thanks for sharing, colleagues. Let's move to the next point. I want us to look at the author's options. Okay, you as an author, what options we have? We have what you call, in regards to the copyrights, okay? Authors has two options regarding to copyright transfer. Remember that you've spoken that your copyright could also be transferred, okay, to the next person. The first one is a traditional way or option, where all rights are transferred to the publisher. In other words, now, whoever publishes your work has an overall copyright on your creation, or on your, let's say, for example, on your article, if it's an article. In other words, you do not have control over your work. They do whatever they want to do. You are the one who have worked on the article and so on and so on, but you gave them the copyright to say, you as a publisher, you have 100% copyright on my work. Then also have what you call the one which we are looking at now. This was the old way of doing things. Now we have what you call the modern option in regards to the copyright transfer. Then we talk about aspects like the Creative Commons, where and also licensing. Copyright holders license partial rights to the other part. In other words, the modern way, you can give what you call Creative Commons. We'll talk about that sooner. Or it could be an issue of licensing. In licensing, it means that you also, as the creator of the content, you have at least 50%, right? Or partial, it could be 50%. And the publisher could also have some copyright rights, for example, 50%. In other words, you are also having control over your work. So you need to decide whether you go the old way or you go the modern way or option, but you go to the way of licensing, okay? And all of these things, colleagues, most of the time, when you finalize your submission with the publisher, these things are going to be requested from you. It's a very it's a consuming task, but you must understand. And what I like with them, the publishers, they will explain all these things to you, to say, if you give us licensing, these are the conditions, these are, you see, so that when you choose for the Creative Commons or you choose for licensing, you are familiar what you are choosing about. You become aware, okay? Then you have what you call the open access publishing. I think I've spoken about this one, whereby your work can be accessed by anyone, or you give your work for open accessibility. If you say to the publisher, there is my work, make it open. Everyone can download, can do all of this. If I can give you a simple example, when you try to source material and maybe use maybe some of the platforms, like for example, if you go to Google or maybe go to Eric, all right, then you want to source some maybe articles which are related to your topic. You'll get two types of the sources there. The other one, you may find that you are able to download. Okay, it gives you an option to download. The other one, it doesn't give you option to download. So in other words, the accessibility, the other one where you are able to download the article, it means it falls under open accessibility from the publisher. You can download, you can click on the article you are looking at, and you can download, you can print and do all this stuff. But the other one, you find that maybe it's more PDF most of the time. It's going to be PDF. And when it's PDF, what it says, when you go through it, sometimes can tell you that for you to be able to source this article or this document, you need to liaise maybe with your library and so on and so on. In other words, it's money. It's not a free publication, so you need to pay. So when you give licensing, the publishers, they also show you all those aspects, okay? But let's quickly look at open access publishing. In other words, we publish in a platform where our work can be viewed by anyone at any place. Well, it has a lot of advantages, okay? In other words, for example, if you are on the platforms like the ResearchGate, it tells you about there's a score there, and that score sometimes it also indicates how many people, maybe how much you've published, and also it tells you about how many people have cited your work and all of those things. So in other words, you are able also to see how many people have looked at your work, how many people have read your work fully, okay? Because the content you have put is more, it's an open, accessible content. So anyone can look at it, maybe and also read in full, okay? So it has those advantages. Unlike if, for example, it's not an open access option, okay? Whereby it's a PDF, definitely people must buy your publication and so on, and others they maybe they don't have money to do that, because sometimes when people what they normally do when you look at when you start to download, for example, you want to download an article, where do we start? Well, you have searched it according to your area, but you read the abstract, is it? And if you feel that's what you want in regards to this area of your study, the abstract is not giving you some of them, the aspect you're looking at. You don't even go and download it, is it? But if you look at the abstract, you say, okay, from this abstract, it's what I'm looking for. Then you open the document, then you read it further. Then if you want to download it or print it out, you download and print it out, is it? But if, for example, the abstract, definitely, you look at the abstract, it's not something you are looking for, then just move to the next one, is it? The same thing now. If it's not an open, accessible document, very few people are going to buy it. Well, most of the time, maybe those who buy it, if they see that the abstract talks to their need, they can buy it. Then they buy the whole document, okay? Or if, for example, if you feel that, no, it doesn't talk to your needs, you don't even have to buy the documents. So what they've done now, most of the time, if it's a book chapter, they allow you to buy a chapter in that book chapter instead of buying the whole book. If you want to buy the whole book where there are different authors, you can do that. And most of the time, I think people who are in the library and so on, those are the ones most of the time who buy the whole book. But if you want a certain chapter, you buy that chapter by that author. But let's look at the issue of publication houses. They ensure that before any publication could be made, a publication agreement is signed. Okay, so you have to sign an agreement. If, for example, I'm going to publish with this publication house, I must sign an agreement. And remember that the agreement you are going to sign, they are going to explain to you and give you their options. So you must read them carefully. Okay? This publication agreement entails aspects regarding one, assigning of copyrights. You assign the copyright. Remember, we've spoken about the copyrights. There are two options, okay? Okay. And also exclusive dissemination of rights. In other words, the rights can be also exclusive. In other words, if you sign for this aspect regarding to the copyrights, then and also the rights, you can make them to be exclusive to them, the publication house, to say they have a right to do everything as they please with your output. If they want to put it under certain platforms, they have the right to do that because you have signed for it, okay? And there's no way the publishing houses, they can publish your output or your work without you signing the publication agreement. Remember that all this process, colleagues, where does it start? Let's say it's an article, right? You identify a journal, okay? Then you go through the journal itself, you look at the specification and so on and so on and all of those things. Then from there, you submit your manuscript. Then your manuscript needs to go through a process of peer review. If there's a correction and all of this, then it goes after everything has been done, it's go to to typo and so on. Then they do the layout and all of this. If you are happy and they are happy now, then now they say, let's sign the publication agreement. Then they send you all those documents and so on. Then you give them whatever rights you want to give them. You give them as they stipulated in their publication. Then the author's copyrights could be transferred to the publisher outrightly, all right? Whereas license transfers limited rights to the publisher. In other words, if you say, I give you the author's copyright, it means everything is going to be under the publisher. But if you say, I give you a license transfer, it means the publisher, they have a limitation. They can't do as they please with your output or your document or your article. They need to liaise with you. But when you come to open access platform, will allow the content author to retain the copyrights. Okay. Alternatively, they could also ask the content author to transfer their copyrights to them as publishers. So if, for example, you say, let's go for open access platform, definitely, you still have to retain a little bit of copyrights. But if you feel that, no, let's look at how these copyrights can be handled, then I give you at least a partial, all right, in regards to copyrights. So you are able to work together with the publisher. In both cases, this means that content author who holds the copyrights given consent to the open access for their published work. In this case, in which the publisher hold the copyrights, will consent to open access directly. All right. So those are the things which I think as time goes on, colleagues will try to understand them better. Okay. But what I'm trying to position here is that remember that your work, it needs at least to belong to you as much as possible. And I'm bringing all these topics to you guys because what I know, as soon as you have your own first output, could be an honors report or a master's or a PhD, there are people who are going to ask to publish their work on your behalf. And please, those we call them the phishing publishers. You must be careful about those people. Okay? Don't assent to them. Don't even give them that permission. And we'll talk about, I think, when we address the topic of publishing, to how do you notice those type of publishers? And they're always, some of them, colleagues, I think, going forward, maybe some of you have heard about them. Some of them, they can even approach you and say, we are aware that you are writing your thesis now or your dissertation for your master's. We can write it for you. So we need to be alert about some of these things, colleagues. You know, I was looking at something, I think this week also, because I always look at some of these things. There is a workshop which has been advertised, right? I think it's about artificial intelligence. And I said, I'm interested in this workshop. So, but they say it's free. But I look at the people who are going to present this workshop. Someone who is familiar, you're right, in the South African context. But I've said to myself, I'm afraid to put my name around that. I'm not saying you should not. I think some of you have seen that workshop. But for me, I've tried to put, but when I wanted to put a certain details, it didn't allow me. Then I said, welcome, stop here. Okay. I didn't even send an email today to that conversation or comment to say I'm struggling in all of this. I said, no, maybe let me just wait for now, because some of these things, I'm not saying it's not authentic. I think it's authentic from my side because I trust the person. But what I'm trying to say, always before we do something, let's think first. Don't just be excited. I think most of us are familiar about that. We should not be excited by some of these things, okay? Verify first. The same thing with your publication. Verify first before you send, you drop your work in any of the publishers. Because remember that the publishers we are dealing with here, especially in South Africa, there are publishers which we call them the Department of Higher Education accredited publishers. That's the one where we have a list of them. From the library, you can get a list. Others, which they don't appear in that list, we are not supposed to send our work to. Well, other people from other countries, they use them, but we are not supposed to use them. The reason why is that if your work is being published under those platforms, it means you are not going to get any money from the Department of Higher Education. Remember, the publication, it goes with money and all of those. So you are not going to get anything. It can be a publication. It's fine. You can put it under your profile. But for us, we want publications which are going to give us something. You as a student also, you can also do that. When you publish with your supervisor, there's something I think which is coming up. I'm not sure about the process, but I know there's something. I don't know how do they work it out. Let's quickly look at what is Creative Commons. That's a new licensing model we are working with now, right? Basically, a Creative Commons license is a license issued by the copyright owner. You are the one who issue that license, okay? Sorry. To allow anyone in the world to use his or her copyright work in any manner consistent with that license. In other words, you have to determine and indicate in this license how your work is going to be used. Creative Commons licenses are essentially standard form license agreement, which can be attached to a work to enable its use under certain circumstances without the need to contact the author or negotiate terms of use. In other words, you give the publisher this license, okay? Then they can make a decision, right? It's an agreement, by the way. But when you look at it now, it is more applicable to the authors who would like to share their work widely. We all want our work to be shared widely, is it? We want our work to be read across the globe. So we can use the license, the Creative Commons license. It allows us. It doesn't restrict the sharing of our work. I want us to, I'm hoping that's going to work here. All right. I want us to look at these license conditions under the Creative Commons. There are license conditions there. Let's quickly try to look at each one. The first one, it says, if you can see a symbol there also, it talks about attribution. Basically, the license lets others distribute, remix, or tweak and build upon the work, even commercially, as long as credit is given to the original creation. All right? In other words, if you give this publisher this type of a license condition, which you call it attribution, it means you give them a go ahead, all right, to build upon your work, to remix it, okay? But they still need to give credit to you as the creator of that work. Then we have what you call, yes. Then we have another one which you call it the non-commercial. You can even see there are dollars there. In other words, the work cannot be sold, is it? It's non-commercial. In other words, this license allows others to remix or tweak and build upon the work non-commercially. New work must acknowledge and be non-commercial. commercial. In other words, whatever they do with your work, give them a license, right? To say, okay, you can do whatever you want to do with my work, but you should not benefit or get any money from whatever you have done. If, for example, you have remixed or tweaked some of my work. So at least people are not going to benefit unduly from your work. So you have this type of a license. And all these licenses, they fall under the Creative Commons platform, which call them the modern way of giving copyright, is it? Another one, we call it non-derivative rights. It means this license allows for redistribution, commercial and non-commercial, as long as it is passed along unchanged and in whole with credit to the creator. In other words, now, as long as you work on my content and you have changed nothing, and also you have acknowledged me. Okay. Other license condition is called share alike, right? This license let others remix also, tweak or build upon original work, even for commercial use. In other words, here, whoever publisher you've given them the rights for share alike. In other words, they can also take your original work, and at the same time they can even benefit along it, as long as there is credit and it's licensed and it is licensed as a new creation under the same terms used for open sources and software license, as long as they credit you. Okay. Just to go quickly to those license conditions. As we are looking, maybe I could have shared a document which also has some of these license conditions so that you see them. Okay, but most of the time the document itself or whatever publication is there is going to tell you about this type of licensing according to the publisher. Okay, what copyright you have given them. There are 6 types of Creative Commons licenses. I just have to go through them, colleagues. I'm not going to explain them in detail, but what are they? I'm hoping that it's going to give me, okay, I want to open all of them. Here are they. If you look at the first one, it's called attribution. And when you look at some of the symbols, look at this one, got a lot of symbols. This one also, and this one, and this one also. But if you look at this one, attribution, we've spoken about it. Okay? But it also have what you call this symbol. Basically, attribution, it means this license, it enables the reusers to distribute, you've spoken about then, that and build upon material, so long as credit is given to the creator. We've spoken about that one. Share alike, we've spoken about that one also. Okay. We've spoken about no directives. All right. Sometimes you may find that in one of the licenses, in one of the publishers in your document, all of this, they appear. So, okay, for example, look at this one also. It tells you that there is an attribution. You can share, you can retweak, as long you credit me. Okay, this one tells you that sorry for this, there's no derivatives and so on. But what does it mean? It means it also enables the reusers to copy and distribute the material in any medium or format, right? And only so long as attribution is given. You still have to give attribution, okay? And the license allows for commercial use. Okay, so if it allows for commercial use, and look at this one, all these things are common, but it doesn't. This license does not allow for commercial use. In other words, whoever retweak or remix your work as you have given to the publishers, they are not allowed to benefit for what they have revamp or what they've tried to tweak around your original work. So all those things, colleagues, we need to be aware of. So, but most of the time, definitely, like I've said before, your work could be published. You are supposed to sign to have an agreement to say what type of copyrights are you giving to the publisher. I've just put this just from my side as I'm able to notice some of the aspects. The first one I've said, you need to decide about the rights that you want to retain. And I always say to the student publishers, at least you should have make sure that the copyright, I'm not sure, but I believe they should not give the publisher a full copyright. You need also to have a say, a little bit there, definitely. Rather opt for publishers who would allow you to retain most of the rights. That would be ideal, but somewhere, somehow, they also want to have some rights around your work, but at least you also be part of the decision they make, okay? Read and familiarize yourself with the publisher's agreement. That's very important, especially if you are about to publish your first your first manuscript. But I think your supervisor will be there to guide you around that. But going forward, if you are the sole publisher, make sure that the platform you choose is the correct one. If you're not sure about it, maybe you need also to consult people maybe who can assist you around that. I'm not quoting that, colleagues, also, but what I normally read, I also read the agreement. I sit down and read and understand, say, okay, am I agreeing to this or not? I want us, I know that there are students definitely who are working on their group research. So I want us maybe next week to look a little bit on the concept of group dynamics, especially when we work on research. Because I know that some of you guys, you'll be working on group research going forward and so on. And some of you are already working on your projects as a group and all of this. Though there are other aspects which I want to share, and some of them I'll share them from my own experience up to this far, working in certain group research and all of this. So I want us to touch on that topic so that going forward, we look on how to the process of publishing and so on. And also somewhere also in August, we look on the issue of presenting our work. I know that some of you are aware that there's a call for the coming research, is it, what do you call it? Conference for students. I think I've seen it under my UNISA. If you go to my UNISA, there's a call for abstract submission for the coming student, what you call it, conference, something like that. So if you go to my UNISA, you're able to see that request. So maybe some of you are interested to submit your abstract there. I've already have one student definitely indicated that the student will be submitting her work there. So maybe after as we will be working on some of the topic this month, you'll be able to know on how to write a manuscript and how to write an abstract and all of this. Maybe after that workshop, you'll be interested to also to be part of that conference for postgraduate students, you know. Yeah, but those are the things which I'm going to share in the month of August. Then others will share them maybe in the following month and so on. Okay, colleagues, thanks for embracing the session today. Thanks for coming, and yeah, I really appreciate your attendance for today. Thank you, everyone, and bye.